Exam Scholar, Real Estate Edition.
Question 1. Which of the following items could not be used by the owner of a hardware store as security for a loan, under the provisions of the Uniform Commercial Code? A. A personal note endorsed by him. B. Accounts receivable. C. Stock for sale. D. Equipment and fixtures. Answer. C. As the stock will be sold, it cannot be used to secure a loan. Question 2. A valid escrow requires which of the following? A. Escrow instructions with no conditions. B. A binding contract between the buyer and seller and the conditional delivery of transfer instruments to a third party. C. The services of a licensed real estate broker. D. None of the above. Answer.
B. A binding contract between the buyer and seller and the conditional delivery of transfer instruments to a third party are required for a valid escrow.
Question 3. If the loan-to-value ratio is low. A. The equity in property is high. B. The equity is not affected. C. The equity in the property is low. D. None of the above. Answer. A. Loan-to-value ratio is the ratio of the loan to the appraised value. If a 90% loan-to-value ratio is given by a lender, that indicates a 10% down payment, and a beginning equity of 10%. If the loan-to-value ratio is only 60%, the down payment is 40% and the beginning equity is 40%. The lower the loan, the higher the equity. Question 4. Sellers are usually reluctant to cancel an existing transferable fire insurance policy in the event of a cash sale, due to the fact that A. A buyer may not properly cover the property. B. A higher short-term cancellation rate will apply. C. It could result in cancellation of other policies. D. The elimination of a cash return in the proration. Answer. B. A seller on a cash sale would be reluctant to cancel an existing transferable fire insurance policy because the seller would receive a short-term cancellation rate. Therefore, the seller would prefer to transfer the existing policy to the buyer. Question 5. A minority purchaser enters your office and states they are looking for, and interested in purchasing, a particular property in a minority neighborhood. You could legally assume that A. This person is testing you and your legal procedures. B. They are interested in that particular property. C. They are interested in owning a home in an all-minority neighborhood.
D. They cannot qualify to own property in a higher-priced area. Answer. V. Should any prospective purchaser enter your office requesting to see a particular property, you would assume they were interested in that particular property. Question 6. A subdivider and developer purchased considerable acreage and now plans to construct a tract of 40 homes. In arranging the financing for the new construction, the lender has agreed to advance part of the funds immediately and will release a set amount of additional money as each home is completed. The funds that will be forthcoming as construction progresses are known as A. Obligatory advances. B. Reconveyance funds. C. Release monies. D. Open and mortgage payments. Answer. A. This type of construction financing is referred to as obligatory advances or fixed disbursement schedule. Question 7. All of the statements below are true, except A. A grant deed may convey after acquired title even when such warranty is not actually written into the contents of the deed. B. A quitclaim deed may convey any right or title including fee simple title. C. A deed is of no effect unless delivered. D. A reconveyance deed is used to convey title to a new purchaser in connection with a trust deed sale. Answer. D. A reconveyance deed is given by a trustee to the borrower, known as the trustor, after a loan has been paid in full. The borrower records his deed of reconveyance to clear the loan lien from the record. Question 8. Which of the following is not a necessary element in the formation of a contract? A. Offer. B. Acceptance. C. Consideration. D. Performance. Answer. D. Two parties may enter into a contract, but they might not fulfill, also known as perform, their obligations. Question 9. Lenders use the term debt-income ratio to refer to A. Part of closing costs. B. Loan qualifying tool. C. Requirement of the federal government. D. Formula used in appraising property. Answer. B. Debt-income ratio indicates the fraction that your loan payment on the property is in relation to the net income from the property. This is used by lenders when qualifying a person for an income property loan and measuring their margin of safety. Question 10. A prospective client calls you and asks you to take a listing on his property. In reviewing his papers, you discover he is purchasing the property on a contract of sale that has no acceleration clause, and that has no provision in the contract prohibiting a resale or an assignment. Which of the following is the most nearly correct statement? Your client could A. Sell his interest in the property, but only if he pays off the contract first. B. Sell or assign his rights but not his duties under the original contract unless the contract seller's approval was obtained. C. Properly give the purchaser a warranty deed to the property providing the deed recited subject to the existing contract of sale. D. Properly give the purchaser a grant deed to the property, providing he took back a recorded purchase money second trust deed to cover the payments due on the original contract of sale. Answer. B. A party purchasing property under a land contract of sale may sell their interest without difficulty by assigning the contract, provided there is no prohibition on the agreement. The assignee would still be secondarily liable for some of the terms of the contract unless the seller's approval was obtained.
Passing the real estate exam can be hard, like really hard. Statistically, only about 50% of people actually pass the real estate exam on their first try. Those people that pass, they go on to become real estate agents. And the people that didn't pass, they either give up completely or have to try again. Both of these options are painful, disappointing, and upsetting. Exam Scholar Real Estate Edition has been named as the best real estate exam prep by multiple publications for 7 years in a row. If you are about to take the real estate exam, Exam Scholar Real Estate Edition is a no-brainer choice. There is no other real estate exam preparation service out there that comes close. To enjoy the longest membership time, lowest cost, real estate videos, audios, articles, flashcards, vocabulary, exam tips and tricks, a 1-year no questions asked refund policy, and be one of the 35,000 people that it has helped pass the real estate exam, then sign up in less than 5 minutes at www.realestateexamscholar.com.
Question 1. Many real estate contracts are in writing on forms. Parts of these contracts are written and parts are printed. In the interpretation of such contracts, A. Printed parts take preference over the written parts. B. The written parts and the printed parts are given equal consideration. C. The written parts take preference over the printed parts. D. Any parts copied from the form take preference over those that are purely original. Answer. C. As regards to contracts, the written takes preference over the printed parts and oral agreements take preference only when the written contract is incomplete or ambiguous. Question 2. A lender possessing a chattel mortgage may A. Assess it. B. Hypothecate it. C. Alienate it. D. All of the above. Answer. D. A chattel mortgage is a mortgage secured by personal property. Such a mortgage may be used as security for an additional loan. When the property is put up as security for a loan and one retains possession, it is said to be hypothecated. Personal property may be assessed for personal property taxes and/or federal estate taxes. Question 3. A real estate broker is usually A. A fiduciary to a person interested in buying a property the broker has listed. B. An attorney in fact. C. An agent serving the principal under a duly executed power of attorney. D. None of the above. Answer. D. The broker is usually the agent, fiduciary, of the seller and usually does not have a power of attorney. Question 4. When a broker shows a client's property to a prospective buyer that is listed with the broker under an open listing, the broker should A. Make up an office memorandum. B. Confirm the showing to the buyer. C. Notify the seller as to the prospect's identity. D. Notify the local real estate board. Answer. C. Notifying the seller establishes the broker's right to collect a commission as procuring cause. Notifying the seller as to the prospect's identity provides the only effective way of establishing that right. Question 5. Concerning business opportunities. A. The bulk sales law is contained in the Uniform Commercial Code. B. A bill of sale is used to convey title to business items. C. Sales tax is a tax on the sale of tangible personal property. D. All are true statements. Answer. D. All of these statements are true. Question 6. A licensed real estate broker working under a typical exclusive listing incurs several expenses. He is not entitled to be reimbursed for these expenditures, unless A. The buyer has demanded that these expenses be incurred as a condition of continuing with the transaction. B. Such expenditures were authorized by the principal. C. It was necessary for him to incur the expenses in order to close the sale. D. The broker was representing the best interests of the principal in consummating the sale. Answer. B. A seller is not obligated to reimburse the expenses of the broker unless those expenses are authorized by the seller. Question 7. A primary justification for zoning ordinances is to A. Maintain conformity to buildings in the zoned area. B. Prevent an oversupply of certain types of businesses. C. Promote public health, safety, morals and general welfare. D. Control the quality of building construction. Answer. C. Zoning laws are the exercise of police powers which are for the public health, safety, morals and general welfare. No compensation need be paid in exercise of police power, as they are for public protection. Question 8. A salesperson receives a deposit together with a written offer to purchase and delivers them to the employing broker who presents it to the seller. The seller signs and accepts the offer. Without the consent of the salesperson and through no fault of his own, the buyer and seller instruct the salesperson's employing broker to return the deposit. Which of the following is true? A. The salesperson's employing broker may retain 1/2 of the deposit and must give 1/2 to the seller. B. The broker may sue the seller but must return the deposit. C. The broker may retain 1/2 of the deposit and must return only 1/2 to the buyer. D. The broker may retain the deposit to compensate him for his efforts. Answer. B. Once the offer has been accepted, the deposit money belongs to the seller. If the seller instructs the broker to return the deposit, the broker must do so. The broker has probably earned a commission and may sue the seller for the amount but may not hold the deposit money. Question 9. An attorney drew up a contract between a buyer and a seller for the purchase of a property. The agreement included a liquidated damages clause calling for the payment of $500 in the event the buyer should default. Prior to the close of escrow, the buyer decided that the home would not suit his family and canceled the purchase. If the seller were to sue for specific performance, he would most likely be A. Successful because the $500 is not adequate considering the value of the property. B. Successful because the reason for canceling by the buyer was not strong. C. Unsuccessful because the seller agreed to accept the $500 as liquidated damages in the contract. D. Unsuccessful because an attorney drew up the contract. Answer. C. Since both buyer and seller agreed to the liquidated damages, the seller has agreed that if the buyer defaults, then his sole claim will be to the $500 only. Question 10. A second offer received on a property prior to the seller's decision on the first offer should be A. Evaluated by the broker against the first offer. B. Submitted immediately. C. Held pending a decision on the first offer. D. Turned back to the offer if it doesn't provide better terms. Answer. B. All offers must be submitted immediately. Question 1. In portfolio risk management, a lender considers A. Diversification. B. Liquidity. C. Reserves. D. All of the above. Answer. D. In portfolio risk management, a lender determines what type of loans to have in his portfolio. Factors are: how quickly can I sell these loans? What are my reserves? How diversified are these loans? Are they all business? Are they all residential? Are they a mixture of business and residential? Question 2. You sell a note with a face value of $12,000 for $10,000. You are A. Discounting the note. B. Amortizing the note. C. Committing an act requiring a real estate license. D. Committing fraud. Answer. A. Any time you sign a note or sell a note and the amount you receive is less than the account stated on the face of the note, you are discounting the note. Question 3. An able buyer means one is A. Financially able. B. Having the ability to obtain the necessary funds to purchase real property. C. Having the ability to obtain necessary financing. D. Any of the above. Answer. D. Any of these would indicate an able buyer. Question 4. The right to foreclose a trust deed, under a trustee's power of sale, outlaws A. In 4 years. B. In 3 years. C. In 2 years. D. Never. Answer. D. A trust deed is not a contract, but rather a conveyance of the naked legal title with the power of sale from the trustor to the trustee. Therefore, the trustee retains the right to sell the property under the trust deed at any time for the benefit of the beneficiary. The conveyance has been performed and thus is not under the statute of limitations, therefore, it never outlaws. Question 5. Broker Styles took a listing from a seller using the standard listing form. 1 week before the listing expired, The broker informed the seller that he had a prospective buyer named Bennett. After the listing expired, the seller listed with broker Johnson. Johnson showed the property to Mr. Bennett and obtained an offer that was accepted. Under these circumstances, A. Broker Styles gets a 6% commission. B. Broker Johnson gets a 6% commission. C. Both brokers get a 6% commission. D. Broker Styles gets a 3% commission and Broker Johnson gets a 3% commission. Answer: B. In the safety clause of the standard listing form, Broker Styles would agree to relinquish his safety period if the property were listed with another broker. Question 6. A loan created with more than one borrower is usually added to the promissory note for the protection of the lender. A. Beneficially. B. Jointly and severally. C. Universally. D. Unconditionally. Answer: B. When there is more than one borrower on the note, the promise and obligation to pay that balance is the responsibility jointly of all the co-borrowers, and also each individual is severally liable for the full debt. Severally, in law, means individually. Question 7. Mr. and Mrs. Johnson, who had been shopping for a new home, found one that they liked very much, but because they felt the property was overpriced, they decided not to buy it. Their reason for not buying was probably based upon the principle of A. Conformity. B. Substitution. C. Highest and best of use. D. Anticipation. Answer: B. It must be assumed that our buyer has found another home that was equally desirable but at a much lower price. This is the idea behind the principle of substitution. Question 8. When a broker misrepresents his principal's property to a buyer, he could cause his principal to be subject to A. A court action for damages by the buyer. B. A rescission of the sale by the buyer. C. Civil responsibility for compensating the buyer for misrepresentation of the broker. D. Any of the above. Answer: D. The principal is responsible for his agent's actions. If misrepresentation occurs, there should be a rescission of the sale or civil court action for damages. Question 9. An owner of a 5-unit apartment building that is located within the city limits intends to convert the building into 5 condominium units and offer them for sale to the public. Under these circumstances, a developer A. must obtain a public report from the Real Estate Commissioner under the Subdivided Lands Act. B. must file a map with the city under the provisions of the Subdivided Map Act. C. is exempt from the Subdivided Lands Act and the Subdivision Map Act. D. must comply with the Subdivided Lands Act and the Subdivision Map Act. Answer: B. Any type of subdivision located within the city limits is exempt under the Subdivided Lands Act, but a condominium conversion of 5 units or more is covered under the Map Act and must be filed with the local authorities. Question 10. After acquired title is conveyed in any trust deed for the benefit of the beneficiary, it conveys A. personal property later affixed to the real property so as to become real property. B. improvement built on the land after title is acquired. C. additional land acquired afterward by the trustor. D. all of the above. Answer: D. After acquired title refers to title to fixtures or other real property items that become part of the land that is securing the existing trust deed. If a lot serving as security for a loan made 10 years ago has land affixed to it, that land becomes encumbered with the lien made 10 years ago. If additional improvements, such as a swimming pool, added bedroom or new landscaping are added to the real property, They to become encumbered with a trust deed lien made 10 years ago. Question 1. During broker Shaw's preparation of the exclusive authorization and right to sell on seller Norman's property, Norman asked that a clause be included which would require the buyer to accept primary liability in connection with when the existing loan is transferred to the buyer. Shaw should enter which of the following in paragraph 2 of the exclusive authorization and right to sell? A. Buyer to take the property subject to the loan. B. Buyer to assume existing loan. C. Buyer to pay all cash. D. Buyer to make a large down payment to preclude possibility of a foreclosure. Answer. B. If a buyer assumes an existing loan, he accepts primary liability for that loan. Question 2. A third party who takes a promissory note that is complete and regular and has no knowledge of any defects is known as A. An endorser. B. A maker. C. A payee. D. Holder in due course. Answer. D. The party that accepts the endorsed note from the original payee without knowledge of any defects is known as the holder in due course. Question 3. The owner of a single-family residence plans to sell and wants to obtain an FHA appraisal to permit a sale with FHA financing. He should A. Contact the nearest FHA office for an appraisal of this property. B. Have a lender apply for a firm commitment. C. Have a lender apply for a conditional commitment. D. Submit a recent appraisal of his home to FHA. Answer. C. The recommended process for the lender to contact FHA for a conditional commitment, that is, for advance assurance that an FHA loan will be made, establishing the loan value for the house. Question 4. A buyer defaults in making payments on a loan, therefore the lender's action probably would result in A. Subordination. B. Escalation. C. Acceleration. D. Alienation. Answer. C. Acceleration indicates the right to declare the entire sum of a note to be due and payable immediately. Most trust deeds contain several acceleration clauses. Most common states, if you become delinquent in the payment on this note, the entire sum of the note becomes due and payable immediately. Other states, the entire sum of the note is due upon the sale or transfer of the property triggered by the sale of the property and therefore is a specific acceleration clause. The rule is, alienation clauses are types of acceleration clauses, but not all acceleration clauses are alienation clauses. Question 5. Which of the following is the classic definition of the boundaries of real property? A. A surface area indicated on a map. B. A reasonable use of airspace and extended to the center or the earth. C. A reasonable distance down and unlimited airspace. D. A practical or reasonable use of the earth and unlimited airspace. Answer. B. The surface of the earth and the material beneath the surface to the center of the earth is part of the real property. Since airways are now public domain, the ownership of airspace is used to an enjoyable and reasonable height. Question 6. A buyer defaults on a loan, therefore the lender would be able to cause the promissory note to become due and payable. This clause is A. A subordination clause. B. An escalator clause. C. An acceleration clause. D. An alienation clause. Answer. C. Acceleration clauses are several different types and reasons. Question 7. In general, when the supply of a certain commodity increases. A. Price tends to rise. B. Price tends to drop. C. Demand for it tends to rise. D. Demand for it tends to drop. Answer. B. If demand is constant and supply increases, sellers compete with each other by lowering prices. Question 8. An offer to purchase real property was signed by a prospective buyer on October 2, 1977. The terms of the offer allowed 5 days for acceptance by the seller. Because of an illness in the seller's family, the seller did not accept the offer until October 10, 1977. Which of the following statements is correct? A. The buyer may demand the return of his deposit. B. The buyer must continue with the purchase because he did not withdraw his offer prior to acceptance. C. If the buyer does not complete the purchase, the seller is entitled to the deposit. D. If the buyer does not complete the purchase, the seller and the broker will each be entitled to 1/2 of the deposit. Answer. A. This constitutes only an offer, and one method of terminating an offer is the expiration of a specified or reasonable length of time for the acceptance to be communicated. Question 9. An offer by one of the parties to a real estate transaction to carry out that party's part of the contract is called a gratuity. B. Satisfaction. C. Recourse. D. Tender. Answer. D. Usually made at the conclusion of the transaction, the tender is the offer to perform on the terms agreed to. If the other party cannot perform, then the party that made the tender can rightfully claim the other party defaulted. Question 10. Should a person be discriminated against, what would best describe the actions available to them? A. Private action in a state or federal court. B. Civil action in state superior court. C. Criminal action in a state court. D. Criminal action in a federal court. Answer. A. As discrimination is not a criminal act, we would eliminate answers 3 and 4. 2 is incorrect as the remedy available to the injured party is not limited to only action through a state court. It could take place through the federal courts. Question 1. Which of the following factors primarily affects supply in the real estate market? A. Population. B. Demographics. C. Employment. D. Government financial policies. Answer. D. Population, demographics and employment impact demand for a commodity, but government fiscal, spending and taxing policies strongly influence availability and cost of credit for those who produce things to be sold, like new homes. Question 2. Of the following, the method which allows the most depreciation to be taken during the first year would be A. Straight line method. B. 150% declining balance method. C. 200% declining balance method. D. Sum of the year's digits method. Answer. C. The 200% declining balance method of depreciation allows the most depreciation for the first year. The sum of the year's digits method allows the most depreciation in the earlier years. Question 3. Daniels purchased 60 acres of land near a city. He intended to subdivide it for sale as single-family residential lots and sell the lots for cash. Daniels needs maximum financing to put in streets, curbs, gutters, sidewalks, etc. He wants to pass the cost of these to the lot purchasers in such a way that when title policies are issued to future lot owners, the policies will contain no reference to assessment liens for the above stated purposes. Daniels' best course for financing these needs will probably be A. Real property sales contracts. B. Improvement bonds. C. Interim loans from institutional lenders. D. Corporate stock. Answer. C. Answer B would result in assessment liens. Answers A and D are not specifically financing means for such improvements. By elimination, answer C is the best choice. Question 4. A new well and pump were installed on a parcel of land. For property tax assessment purposes, the county assessor would consider these as A. Improvements. B. Additions. C. Part of the land. D. Personal property. Answer. A. A well and pump would be improvements to the real property. Question 5. Which of the following factors is most likely to influence demand for real estate? A. The number of real estate brokers in the area. B. The number of full-time real estate salespersons in the area. C. The wage levels and employment opportunities. D. The price of new homes being built in the area. Answer. C. When wage levels and job expansion are increasing, workers are more likely to buy real estate. When wages are stagnant or declining, they hold back from making big purchasing commitments. Effective demand requires not only the desire to purchase a product, but also the financial means to do so. Question 6. The one unity in a joint tenancy holding that is also present in tenancy and common holding is A. Equal right of possession. B. Right of survivorship. C. Equal interest of all owners. D. Tenant in possession can be charged rent for the use of the land. Answer. A. Under any type of ownership, each owner has an equal right of possession. This means that any owner can go anywhere on the property regardless of the percentage of their overall interest. Question 7. As a part of the purchase price, the seller of a parcel of land accepted a purchase money first trust deed which contained a subordinate clause. This clause would A. Guarantee priority of the first trust deed. B. Preclude the buyer from placing construction loans on the property. C. B. Permit the buyer to place a future loan on the property that would have priority. D. Permit additional liens to be placed against the property without the buyer's consent. Answer. C. A loan in a trust deed that contains a subordination clause supersedes the rule the first to record is the first in right. A subordination clause in a note and trust deed is evidence that the lender agrees that a future obtained trust deed may be prior to this loan even though the future loan is recorded later. Oftentimes builders use this clause in a trust deed and note used to purchase raw land from the owner. They offer the owner the full price contingent upon him carrying back financing for the land. The trust deed that he is to receive from the builder must contain a subordination clause in which the owner of the land agrees to be junior in priority to a future recorded construction loan. Question 8. Capitalization is an appraisal process used to A. Convert net income into market value. B. Establish book value. C. Determine net income. D. Establish a capitalization rate. Answer. A. Capitalization of income is a method of establishing the value of income-type properties. Question 9. The type of legal action that would most likely be taken in the event of a default on a land contract would be A. Lease pendens. B. Writ of execution. C. Foreclosure by trustee's sale. D. Quiet title action. Answer D. If the original land contract had been recorded and the buyer has defaulted, there would be a cloud on the title and some form of legal action would be required to clear the title. This would not be a foreclosure but a quiet title action. Question 10. A subordination clause in a trust deed may A. Give priority to liens subsequently recorded against the property. B. Allow for periodic renegotiation and adjustment in the terms of the obligation. C. Prohibit the trustor from making an additional loan against the property before the trust deed is paid off. D. Permit the obligation to be paid off ahead of schedule. Answer. A. A subordination clause written into a loan gives a lower, secondary position to that loan if another loan is recorded later.
Exam Scholar, Real Estate Edition.